Okay, we're going to get started now. Welcome to today's webinar. My name is Helen Hall, and I'm your host for today. I would like to remind participants to continue visiting our website for more webinars because the IEEE USA webinar team will be adding more webinars to the schedule throughout the year. And as I mentioned earlier, please keep your phone muted so we won't have any unnecessary background noises. This webinar is being recorded and will be available in our archives later in the week. And there will be a Q&A session right after the presentation, so please type your questions in the chat pod. Our presenter today is David Oxfield. David is an attorney with Strasburger Price in Houston. He has represented clients for more than 30 years. His area of specialty include intellectual property, international transactions, domestic transactions, antitrust and anti-competition issues, customs, export regulation, contract transactions, technology agreements, and franchise law. If you would like to find out more about David, please visit our website. And I present to you David Oxfield.
Thank you. Helen, would you move the display a little? One more. Okay, so the first thing we want to know about trademarks is what is a trademark? And I put up there 3 unfathomable ideas that are not intuitively obvious. The first is it's an intangible asset protectable at law. What does that mean? It means that there's a statute, at least in this case for trademarks. There is a federal statute called the Lanham Act, and virtually every state in the United States also has its own internal law for that state dealing with trademarks. It's intangible, meaning it's not like land or a building. So it's not tangible, it's intangible asset. The third thing that's important to know in that is it's an asset. So if you're trying to build a portfolio, you're trying to build up your worth of your stock, trademarks are one of the ways you can do that. Now, what does a trademark do? It identifies, like Coca-Cola, and distinguishes goods and services. So you would not think that Coca-Cola was a steam engine or something like that. Now, the last part of just the fundamentals of what is a product, what products does it protect, the last thing that a trademark does is it distinguishes by symbols. So you see, actually you don't see anymore. Helen, can you rotate back one? Yeah. You see those 3 little symbols, the TM, the circle with the R, and the SM? Well, TM and SM, they are sort of intuitively obvious. TM stands for trademark. You use it with goods. SM stands for service mark. You use it with services. And then a circle with an R is statutory. The Lanham Act permits you to mark with the circle R when you've registered a mark with the Patent and Trademark Office, which we'll talk a little bit about before today is over, I hope. Now, next page. Not only do we have a distinguishment between a trademark and a service mark, but there's other forms of intellectual property assets that are measured in items for the United States under their laws. One of them is patents, the other is copyrights. So we have trademarks, patents, and copyrights. Patents protect the idea. 35 U.S.C. Section 101 actually is the code to tell you which kinds of ideas are protectable under the patent law. Copyrights protect the expression of the idea, the original work of the author. So at least it has to have some component that's unique. Not much. And it must be original. You can't be a copycat and also enjoy the pleasures of having a registered copyright. Patents, on the other hand, are much more stringent, much more difficult to obtain, much more difficult to protect, and so we will probably not do much either with patents or copyrights today. We postpone those, and we'll speak about those later on in the series. Actually, patents probably in the next case, and then copyrights and trade secrets in the final episode. Now, let's go on to the next slide. Functions of a trademark indicate source or origin of a product. So one of the good things, if you see Winchester, you have some sense that it's probably going to be a firearm. Now, it can be used as a marketing tool to build a brand. It can help guarantee the quality of the product with the mark. In essence, real lemon juice, you expect to have a certain taste, presuming you like lemon juice, a taste that is reproducible, something that you expect to have every time you use it. It creates and maintains a demand for the product. I want a McDonald's burger, you may have heard your kids say more than once. Then finally, it acts as an asset to a company. Again, as the mark becomes more known to the public, so does what you can sell with it, and you put in money for advertising, things of that sort, and when you do so, you begin to have an ownership interest, a building up of assets that can be used later. Okay, that brings us to the next slide, which are types of trademarks. You see the little TM, remember, that means it doesn't have to be registered. All you have to do is put that on your goods, and it shows other people that you intend to use it. Unfortunately, you have to show that the public associates the goods then with the mark, which is not so easy. And so it's usually better, and we'll talk about this in a few minutes, it's usually better to have yourself, with your trademarks, registered federally. Okay, next slide. Okay, what kind of marks can you have? One is words. Crest, guess, tide, all words. Now, they may have pretty pictures about them, logos, but for your purpose, you're saying, I don't want anybody using the word crest if I'm trying to keep the word crest to myself, no matter what form it's in. Next slide. Next is names of marks. You can have actual names. Abercrombie and Fitch is one that actually I enjoyed helping rescue. Tiffany and Company. Any of those, Ben and Jerry's. They're all names, but they're names that have become distinctive of the mark and the goods associated with the mark. That brings us to symbols. As you can see, you have Nike, you can have that marvelous football team, the Texans. You can have all kinds of names through symbols. And the more you get fanciful with regard to symbols, as we'll talk about again in a minute or so, the more likely you are to be able to register your mark and to be able to use it successfully by asserting it against others so they can't use your mark. Now, other things that you don't think of so readily, and we need the next slide for this, are sounds. Oop, that didn't work so good. Well, it's meant it's meant to show MGM's Lion Roar or NBC Chimes. And that's what the sound is for. Let's go to the next slide. And sure enough, there they are, showing up. Keep going, another slide. The NBC Chimes, keep going, another slide. One more slide. And Pillsbury Doughboy. Okay, colors is the next item up. Home Depot uses orange, Owens Corning uses pink. These can help distinguish your product, make it more yours, and make it more readily accessible as a feature. Next number. Devices can also, because of their fanciful shape, they can also, like Coca-Cola's bottle, be something that can act as a trademark. Next number. Finally, we have scents that can be used as trademarks. As you see, the plumeria, scented thread. Next number. Finally, marks don't have to just be one thing. They can be slogans, like the King of Beers, or Breakfast of Champions. Those are marks too. And then we have domain names, Google and Amazon, as you can readily see. Now, one more thing, again, to caution you, marks work not only with goods, products, but they also work with services that are performed, accounting services, almost anything you can think of. In this case, Weight Watchers and FedEx delivery services, and hopefully losing weight services. Next, we go to levels of protection, and I'm going to go quickly through this first group so you get the overall picture, and then I'm going to come back and go through each one of them so that you begin to understand what happens to marks if you're not careful, as well as what happens to marks if you are careful. So we have going from the highly protectable, easy to get a registration for, and very difficult to fight, and pretty easy to protect from nefarious infringers. So we have 5 kinds of marks. You have fanciful, and we're going to go through all these in detail. Arbitrary, suggestive, descriptive, and generic. Now, the only thing I've said that's misleading in this is the fact that when you get to descriptive and generic, you no longer have a protectable mark, as we're going to find out in a minute or so. Fanciful is first. Next slide. A fanciful mark has no meaning before you use the mark. That's why it's called fanciful. So if it has a meaning, then it's going to fall under one of the other categories, and if it falls under one like refrigerator, then you probably will never be able to protect the mark because it's become the generic name of the goods. But going back to the fanciful again, it's no meaning before you actually use the mark, and use of the mark means shipped it in commerce throughout the United States or in portions of the United States, or outside, because it also is amenable to foreign registrations as well, and there's a registration process, foreign too. Okay, arbitrary. Arbitrary is a common word, but it is not used for its definition when you're using it on your product. So Dove is, we know now, most of us do, I guess, think of it in terms of, oh yeah, that's soap. Well, obviously a Dove was not soap when somebody first decided to use it. Suggestive is the third. Let's go on more. And now it alludes to some characteristic of the product, but enough to where people will still use the mark to distinguish that product from other products. So Jaguar, Coppertone, 7-Eleven, all are suggestive. They're used, but they're not used for what they want, and they're not arbitrary. Now we come to the bad ones. Descriptive. So if you wanted to put down copper wire and you wanted that to be your mark, in all likelihood you will never succeed. Hamburger helper. says there's something you're going to put in a hamburger. If that's what you're using the mark for, it's going to be descriptive. Next slide. Finally, we come to generic, and generic to a large extent existed before the marks became generic. And I put up two here. The ones I would rather focus on for the minute that we've got are, for example, refrigerator. Refrigerator is a generic name of our fridge, a generic name of the goods. Kleenex. Kleenex is fighting for its identity of its name. Don't go to the generous side yet. Okay, it's going to be forever impossible to get to. Safari for helmets is a generic name for the goods. You won't be able to do anything with escalator. Even aspirin used to be somebody's trademark. Monsanto's in the case of aspirin. And Monsanto, unfortunately, used it in a way that let people make the mark generic, whereas now you find with Kleenex, we don't say, would you give me a Kleenex? We say, may I have a Kleenex facial tissue? That's how Kleenex is trying to preserve its mark, which is on the losing side. Okay, now we're ready for beware genericide. What I've been emphasizing with regard to keeping your marks is to be careful how your trademark is used, otherwise it can fall, glib term, all the way from protected to unprotected. And that's what you don't want. You spend a lot of money on advertising before things are done in products, and you sure don't want to spend the money and then have the money effectively taken by somebody else by not being able to use it exclusively for yourself. Let's go on to the next one. So now let's take one look to effectively see how we use trademarks in marketing. First off, symbols. If you've got a product, put a TM on it. If you're sending out a magazine, put an SM on it if you don't have a registered mark in the United States. The little circle R you don't put on until you have a registered mark in the Federal Registry System of the United States. Next slide. Second rule about trademarks is you always use them as adjectives, not nouns. So I gave you two examples here. Drink a cup of Starbucks coffee. That sounds pretty good. Also, if you notice, Starbucks is an adjective for coffee. So you don't say, drink a cup of Starbucks. That's like asking for an aspirin, or a Kleenex, or a blue jean. Some of those are still fighting and will fight forever, I'm afraid, to keep their marks on a more expensive basis, their marks. Okay, let's go to the next slide. You don't use trademarks in the possessive form. Okay, so just like a second ago, we said you use them as adjectives, not as nouns. You don't use them in the possessive form. So Aveeno lotion's active ingredient is dimethicone. Is right. Wrong is Aveeno's active, notice the word lotion's missing, active ingredient is dimethicone. So when you lost the fact that you were no longer using it as an adjective and stuck it in a possessive form, you did an even worse job for yourself in protecting your marks. Next one. You want your marks to always stand out, to be bold. Use bold font, use italics, use all caps, underline your marks, as you see in those four captures there. And that helps protect the market, focuses the consumer on your product, not so much on your mark. Okay, Next one is do not use trademarks as verbs. Would you make a copy of this paper on the Xerox machine? Fine. It's not a problem. You're not using the trademark as a verb. However, if you say Xerox a copy, and now we come into Xerox's problem, but Xerox a copy is not what you want to use. If you say Xerox a copy, pretty soon everybody will say it's a Xerox. The minute they've used it as a noun, it's deadly for your mark. Let's go on to the next slide. Okay, so we don't make trademarks plural either. Buy a dozen Shipley donuts, not buy a dozen Shipleys. Next slide. Okay, how do you obtain trademarks? There's two ways in the United States. This is not true in foreign countries, and so you need to double check if you deal in commerce in a foreign country. The first is use. This is the one that is not readily available in a foreign country just by using the mark. This is called common law, which is basically England and the United States and Canada. So even if you seek federal registration, you file a a trademark application to register the mark in the United States. Even if you do that, you must use the trademark in order to be able to have the mark affixed to the goods so that people associate with them. So again, use, common law, even if you seek federal registration, you must still use the trademark. You must use it in a trademark sense. It's not true in for example, Europe, except England. You can, in fact, use the mark or register the mark without having used it before. You can't complete registration in the United States without having used the mark. Now, trademark rights are based on territory and type of product. So whether it's a trademark or a service mark is one thing. Territory, usually you can't keep a territory all to yourself. Next slide. Okay, so finally is pretty obvious. You want to make your mark yours. You do not need to register your trademark before you use the symbol TM. You use the symbol TM to express to people that you intend to have this mark be your mark. So it has that goodwill value. People associate the mark and the goods themselves. Second, you do need federal registration to use the symbol R. And that tells anybody who's sophisticated that you have registered the mark with federal government, that it's deemed to be known to be yours by the fact that you registered it, as long as you were the first to register it. Okay. Now, next slide. We already have been talking about register. What is USPTO? United States Patent and Trademark Office. The scope of the Lanham Act, which is the Registration Act for trademarks and service marks in the United States, is one, you get nationwide protection. Better territory than if you just register it in the state of Texas. There you would get Texas protection. I mean, we got a large state, but we're not as big as the United States yet. Anyhow, you want nationwide protection. You want the use of the circle R, which is better benefits than the TM. You can get double damages. You can get attorney's fees. If you sue federally, which requires a federal registration, and you don't necessarily get that with the TM. It gives you evidence of the validity of your trademark. There is a presumption of validity of your mark when you use the circle R as opposed to the TM. With a TM, you've got to prove you have validity of the mark. It also stands as evidence and better protects your brand. So your overall constituency, you want all your pieces to fit together. Your right to a federal registered trademark becomes incontestable after 5 years of continuous use. What does that mean? That means if I register my trademark with the United States Patent and Trademark Office, and 5 years after the registration issues, I am still using it and nobody else is using it or attempting to use it, then I have reached the incontestability point of my mark, and my mark is now incontestable because I've had it for 5 years. The only thing that will make it contestable again would be if it became generic. Remember, generic, that meant it stood for the goods themselves. You can't capture somebody else's goods. So you have the generic name, and the only other reason would be if you got the mark registered by fraud. You said, I use the mark continuously for 5 years, and in fact, for 4.5 years you haven't used it at all, but somebody else is now making it popular, so you're trying to say, well, I had it first. Okay, next slide. And we're just about done now, so if we have any questions, we'll, not quite yet. Well, we have now a technical difficulty. There it is. It's back. Okay. The process of obtaining a registered trademark. You first, to look for a trademark, you go to the Patent and Trademark Office and you dial up uspto.gov, and when you do that, you can then search under trademarks, because it's divided between trademarks and patents. You can search under trademarks for the mark or the word that you're going to try to use as your mark, and you can get a lot of stuff done by yourself without having to bother with a lawyer until you're zoned in on where you want to be. When you're zoned in, then you file an application, and the USPTO will in fact supply you forms of applications if you want them. Although this is tougher, trademarks, than copyrights. Copyrights is really easy to keep as your own, to fill in. It's cheaper to obtain registration by a factor of 3 or 4. But anyhow, you file the application with the USPTO, and there are examiners. And again, in copyrights, there are no real examiner. They just check to see if you filled in the application correctly. For trademarks or service marks, they want to examine it. Sometimes you go back and forth with the examining attorney until you finally get patent trademark prosecution to be yielding your trademark. So you may have an application that needs to be examined. They may find exact mark. That sometimes happens. Like Coca-Cola is already registered. If you file for Coca-Cola, the examiner will kick your mark out and will not let you get a registration because it already exists. But it's that kind of examination that occurs. Now, once the examiner has come to the conclusion that your mark is at least suggestive, remember we had those 5 degrees, 2 of which, descriptive and generic, were not protectable at all. Okay, but approval says at least it's suggestive. And for that, the examiner will give you a registration. Now, at that point, you're not out of the woods yet. After you've gotten approval, the next thing you have to do is wait for the examiner and the office to publish your mark for opposition. And so there is a publication portion of the application that you have to watch out for. One, to make sure it's properly published, and then number 2, to see if somebody else comes in and opposes. Somebody else can say, I used the mark longer than he did. It's my mark. He would cause me injury if you published his mark. All right, you let his mark go through. Okay, that brings us to the notice of allowance. No, go back one slide. The notice of allowance basically says, hello, is everybody still on the line? Hopefully you still are. I just heard somebody say hello.
Yes,
Anyhow, okay. Anyhow, the mark, once it's registered, once it's published for opposition, it has 10-year periods of the term. So in the first case, where remember we said you had 5 years, between the 5th and 6th year you have to file a notice of use of the mark. At the 10th year of that same period, you have to file a notice, a registration, that you've been using the mark for 10 consecutive years, and you can keep your mark for an additional 10 years. By now it's incontestable, so it becomes very important and may be a keynote to your advertising. So you want to be sure you keep this thing for the 10 years. And it takes about 2 years to get through the process of trademarks, just to get to the point where you have a registration that is good and that it's been published and is ready for use with a circle and an R. Because remember, no circle R's until you've got the actual registration. Brings us to the last page. Just a summary. When coming up with a brand for your product, think outside the box. Always go for the fanciful or the arbitrary. Do a search. Remember uspto.gov. Do a search to find out if there are any competitors with similar trademarks in advance to avoid chance of infringement. You don't want to invest your money in advertising to find out somebody's ahead of you. Somebody can get the mark in front of you and use it, and you spent the money so that they enjoy the pleasure of that. Finally, as soon as you start using a brand for your product, use the TM. Remember, you can't use the circle R until you've got a registration. And that concludes my sort of summary for the day. Helen?
If you have questions, please type them in the chat box. Jay, can you hear me?
Yes. Everybody else is pretty quiet.
How long does it take to get a trademark?
How long does it take? Usually about 2 years to get a registration of a trademark. To get the trademark so it's protectable on a common law basis in the United States takes about 15 minutes. What you do is you put the mark on your goods, or you put the mark on your services, depending on which it is. Services meaning advertising. And you ship it outside your state. So it goes in interstate commerce or international commerce. And when you do that, that's enough to protect you as long as you're willing to prove that the public associates the mark with your product. Otherwise, it doesn't do you any good at all. Normal registration time period, including publication for opposition, is around 2 years.
Dave, there are a few questions in the chat box.
Where do I find that?
To your left.
Okay, let's see if I got anything here.
I think Harry has a question.
First one I had was Mark T. But Harry, go ahead, Harry. Harry?
It's in the chat pod, Dave. You see Harry.
Have you any examples of service marks for technical services, good or bad, good and bad? If you can get a mark and you're performing certain engineering services that aren't descriptive in the mark, yes, you can get it and you should. Now the next one is Mark T. Oh, we have a trademark symbol at the bottom of the slides with the logo. And the reason is I don't want somebody else using my logo. And so I want to, again, strive to always have a trademark. I always want the circle R ultimately. So you can put the circle R in the bottom or the top. Remember that circle with an R in it basically says to you, don't use, if you're lawyers, don't use my mark, or better show me that you're quicker at it than I am at obtaining it. Did you see any others, Helen?
Scott has a question.
Yes, Scott.
It's in the chat
Oh,
pod.
see, right. It's in the box.
Well, I can read it to you, Dave.
Yeah, because I'm having trouble finding it.
Okay. If you are writing an article and mention it or refer to someone's product by its trademark, do you need to indicate that it's a trademark?
The answer is you should always, if you're using somebody else's mark, in order to distinguish and say that I'm using it only for illustrative purposes, I'm not trying to steal the mark, you want to use that circle with the R if you've got it, which if they've got it. So what you do is you say, I have a mark, my TM or my circle with the R is, or their TM or their circle with the R is on the product itself. And so I'm saying, for example, he had a Coca-Cola, you put a little asterisk then, take the asterisk down to the bottom of the page and put a trademark of the Coca-Cola company. Usually that will keep you away from somebody else deciding that you're trying to steal their mark and go after you. Ellen, do we have any more?
That's it.
That's it. Okay. Then thank you very much for coming today. And I appreciate you participating. Thanks again.
Wait, one second, Dave.
Sure.
One more question. Are
Okay.
trademarks protected during the filing process?
Trademarks have a common law protection in the United States. They have no protection elsewhere other than your first to use. So the answer is, yeah, you have common law rights in the United States.
Okay. Another question. Do you always have to send the product outside of your state to start the process of a trademark?
Acting somewhat facetiously, no, you can go ahead and send them to Germany. That'll work just as well. And what I'm really saying to you is, you need to send them in interstate commerce, that means outside the state, or in international commerce, Germany, in order to be able to show use of the mark in interstate commerce, which is required in order to get a registration for trademark in the United States, or service mark, you know, if you're advertising in a Gazette or something. Or if you're performing some service for someone, like engineering services. Okay?
And Scott wants to know, when is the copyright webinar going to be held? Dave, you did the copyright webinar already.
No, I didn't.
No,
I
you
did
didn't?
the antitrust one.
Antitrust? Okay.
Yes.
Well, it will be coming up soon. Check our website and for registration, to register.
But it'll be probably a couple, 3 months. Okay?
Okay, we're at the end of the presentation. I'd like to thank everyone for participating.